Hello, greetings everyone. I'm Brian Kajui, an IP associate at Max Advocates, LN Uganda. I'm happy to share with you a few insights on intellectual property for the creative industry, in particular the entertainment industry. With the creative industry, whoever creates content in law, you have what we call rights in that content. It could be, or it ranges from a songwriter, that person has written lyrics for a song. It ranges from people who randomly create content. They post such content on TikTok, on their WhatsApp status, and YouTube, and everywhere. But whenever content is created, it is classified into two. You have professional content that is created. This involves people who professionally actually create content through professional engagements like photographers. You have video guys that create content. Then you have amateur content creation, where you randomly just wake up, you see nice building, nice beautiful scene, you take a photo of it for your own private consumption. However, when it comes to copyright rights or rights that accrue to any content that is created, it matters not whether that content was created by an amateur or by a professional. It remains content. Now, once you've created your content, it might be for your private use, but at the later stage, it may be admired by a third party who may, for any reason, want to reach out to you to use it for commercial purposes. For example, you've created your random video and you've posted it on TikTok. It goes viral, and a certain telecommunication company wants to use it. In that regard, it requires some contractual arrangements, which takes us to the next stage. That whoever creates content, there's a stage at which you will desire to have it exploited. Once the language of exploitation, commercialization kicks into play, then you go into contracting. So I'm going to take you through briefly about the most important things regarding contracting in content creation. Every content creator, be it professional or amateur, you must be mindful of the following. One, before you give out your content, look at what we call understand the nature of the rights you're giving out. Are you giving out exclusive rights to the other person to use them for the rest of their life, or you've put in a clause, what we call retention clause? Under the recent amendment in the copyright, the law now puts a reversion clause that once you've created your work, you've licensed it to someone or assigned it or sold it to someone, be it a song, whatever nature, for as long as it's protected under copyright, you're required to put a retention clause that upon the expiry of 20 years, that work or the rights in that work should revert back to you. But that is subject to the arrangement you have with this other person. So you must be mindful of the retention clause. Do not give out whatever you've created absolutely in perpetuity, whereby you never retain the same. Number two, understand the territory within which your arrangement is going to operate. We've seen artists here in Uganda that have created music. They have signed with record labels. A case in point, a case between Bruno K versus Black Market Records. It's a case that has been litigated in Commercial Court Division of High Court, wherein he had entered into a contract with this record label, for example, and the nature of the agreement created that the territory, when the territory for dispute resolution and enforcement of that contract was, I think, California or Florida. And luckily, High Court saved Bruno K of that draconian clause. Number two, you must be mindful of what we call chain of title. The person using your work must be more mindful of what we call chain of title. Chain of title, it's more like a due diligence. Confirm that this content creator who is giving me this song or this video actually has satisfied all the necessary approvals and consents. So it's a video, confirm that whoever appears in that video has consented to appear in that video. Don't purchase that video. Before you know it, someone who appears in that video will tell you, I never consented to this video being commercialized. I'll give an example. We had a case that involved Bebe Cool and a comedian called Mohanji. Mohanji hosted a comedy show, and that comedy show would call Bebe Cool, an artist in Uganda, to perform. Later, a video was recorded, and Mohanji, after a few months later, uploaded that content on YouTube. Guess what happened? A dispute arose whereby Bebe Cool demanded that Mohanji should pay royalties to him for commercializing his performance in that video that was uploaded. Now, the challenge with that is that it alludes to what I've just explained. Investigate the chain of title. Why? If a person has appeared in a video, that person has what we call performance rights. But the person who has commissioned for that video to be recorded is the one who has copyright in that video. The rest have performance rights. So to that extent, if you're a performer, which is already enshrined in our copyright laws, is that as a performer, you have your performance rights, meaning before that work is commercialized, you must agree on what we call sharing rights. What do I get if the video reaches a certain level? You have third parties that are interested. So those are some of the clauses you must be mindful. Number 3, in general, any person who creates content, when it comes to commercialization, think about 2 types of agreements or contracts. We have pre-production contracts. Actually, there are 3. First one, pre-production contracts. Then we have the production contracts themselves. Then number 3, we have post-creation or post-production. Now, pre-production, those are the ones, if I'm a songwriter, I'm a content creator, we're joint creators, we have to sit down and agree on revenue sharing, what we call split sheet agreements. If I'm a songwriter, I have a co-composer. We have to agree that if I've composed the introduction, he has composed the verse, the third, we need to agree on how much we are going to receive. The next is the production agreements. Now, the production agreements, those are the main agreements. Those will tell you who owns what, who has what, when we are to sell the copyright, who is supposed to retain this. Then lastly is post-production. Post-production, that's where you look at things like endorsement, or people who come and want to look at your work, like someone wants to use your song in a movie, your video, or your photo in a movie. If it's music, we call them sync rights. So those post-production agreements are also rated differently. So as an artist, any content creator, be it professional and amateur, you have to be mindful about those 3 stages in contracting when it comes to content creation. In conclusion, when it comes to content creation, do not be driven by fame and excitement. Most of us were excited by people sharing our work that goes viral on internet, TikTok, website, YouTube, WhatsApp. And once we talk about it, you say, after all, I'm famous. After all, the company is sharing my work, it is viral. Tomorrow, you know the value of that work if that video either goes in the wrong hands or it makes itself in a video or in a movie, probably in Hollywood. Thank you.